and I'm very pleased to be here today with you to discuss the impact of COVID-19 and Qatari labor law. As I said, this is a discussion, so please feel free to step in. I want to understand your point of view. I want to listen to your questions so we can discuss and try to find the best solutions and try to appoint you to the legal solutions that are related with the impact of COVID-19. So, as a way of introduction, it's important to highlight that the labor law was not amended during this pandemic. The labor law is still in force, and all the solutions, or most of the solutions that we will find during this pandemic are in the labor law. We are speaking about the law 14 of 2004, for those that don't know the specific law that we are speaking of. It's the labor law or labor code in force in Qatar. It has been amended several times during the last years, but it's easy to find in Al Mizan or in other websites the current version of this law. Despite the law not being amended, the Ministry of Labor and the Ministry of Public Health issued several guidance notes to employers and employees during this time. Also, those documents, despite not being an amendment to the law, we advise employers and employees to abide by these guidance notes. And why? We have to understand that when the legislator drafted the labor law, it was not considering specifically a pandemic situation. So some of the legal solutions have to be construed in light of the current impact of the current COVID-19 situation. Having said this, let's go to some questions that we have prepared for you today and for us to discuss. So, unpaid leave. A lot of employers use this possibility during the pandemic. The question is it legal for an employer to impose unpaid leave to the employee? I would like to hear your opinions. If anyone wants to step in and provide us their opinion, it would be great. If not, I will proceed in a few seconds. Just give me a second because one of my earphones just dropped. Just 1 second. Let's go. Anyone has an opinion?
It's not legal, but company and employee can agree upon that. But by law, it's not legal.
Exactly, Carla. Perfect. Is exactly the answer that you gave. It's not legal for the company or for the employer, that is saying, to impose unpaid leave. However, it is possible to agree or to draft an agreement between employer and employee in order to turn the unpaid leave as a legal and binding document. This situation has been also highlighted by the Labor Ministry in their document, in the guidance notes that they have issued for the employers and employees. So it's very clear that from the point of the government, this solution is also acceptable if result of an agreement between employer and employee. Any questions from anyone regarding this topic? No? So let's proceed. Reduction of wage. The pandemic crisis and the consequent decrease of activity allows employer to unilaterally determine a wage reduction. Anyone wants to give us their opinion about this topic? Okay, if not, I will pursue myself on this one. Here we face the same situation as we have seen before with the unpaid leave. The reduction of wage is not acceptable unless if it is the result of an agreement between employer and employee. So the employer cannot unilaterally impose a wage reduction. The employment agreement, like all the agreements that we have, is the offer and acceptance. Normally, the employer offers a certain job, a certain function. The employee accepts with certain conditions. Okay? And those conditions cannot be amended unless by an agreement of the parties, which is exactly what happens in this situation. Even if we are during a pandemic, the employer cannot decide for himself, without the agreement of the employee, to reduce wages. We are speaking here not only of the basic wage, but also allowances. Any questions?
Yes, please.
Please go ahead.
Yeah, I just have a question and comment for the unpaid leave. Okay, we cannot force the employee, but actually how the situation might end up that the employer is asking the employee, okay, you can just submit your resignation and leave. This is the first point. The second point for the reduction of salary, you said by both consent of the employer and the employee, both parties have to agree on this. So my question is, it must be in written. I mean, do we have to have a document for this, or just by notifying the employees? And as long as nobody comes back with any comment or rejection, we can consider this as an formal notification to all of them.
When you say notification, notification is not the confluence of the will of both parties. Notification is something that I do for someone else. So if you ask my opinion, I don't think that this is the proper way of doing it. If you have an agreement with the employees, it needs to be one individual agreement for each employee, and I even advise the presence of a witness, so that in the future, no one can say that it was forced to sign against their will such a document. So regarding the second question, so agreement, individual agreement and document for each employee. Regarding the first question about unpaid leave, it's true that at a certain point, the employer might face one of two situations. Either employees accept unpaid leave, or he will have to fire. He will have to terminate contract. This is a possibility, and the employer is not prevented from terminating any employment contract during the pandemic. However, he must comply with the legal requirement. For instance, you spoke about the possibility of the employee submitting his resignation. It can be made by both sides. meaning the employer can also inform the employee, depending on the type of the contract. We can see that further ahead. But speaking about the normal contract, most of the contracts are open term contracts. And as per the law, the employee must give a notice period, which in most of the cases, we are speaking about 30 days or 60 in contracts that have more than 5 years. And the employer has to give only a notice period of 30 days to terminate the contract. So we can do that. It's a solution that the employer has, is to terminate contracts if the employees are not willing to accept unpaid leave. This has to be understood as sometimes as a strategy to make the business or to keep the business alive. Otherwise, it's possible that some of the business have to be liquidated or are in a situation of bankruptcy. So in order to prevent that, it's a valid possibility for employers. Mahmoud,
Excuse me, Ricardo.
did I reply to your question, or have you any further questions?
No, perfectly fine.
I have a question on reduction of wages.
Could you repeat your question, please?
I said I have a question on reduction of wages. When
Okay.
wages are reduced, what about the end of service benefits? Is it going to be calculated and paid off and then a new contract started? Or the new contract begins with an end of service settlement, which means the basic is lower than in 2 years.
Hello.
So what is the calculation then?
Hey, Mustafa.
Hello?
Excuse me, Ricardo. Sorry, Ricardo. Hello,
Yes.
Ricardo.
Hey.
Many of you have your mics open. Can you unmute your mics, please? Except for the person
مش
who's
موجود. قول لي.
Tamer, could you please unmute your microphone? Thank
Please
you.
mute your mic except for Miss Vani, please.
Yeah, Ricardo, did you understand my question? Did you hear it?
I think so. You were speaking about the end of service and how it's going to be calculated if the salary is reduced.
Yes.
Okay. The end of service is only due if the employer or the employee, one of them, terminates the employment contract. So the salary reduction does not necessarily entail the payment of end of service benefit. There is nothing in the law about this. The law only says that the employee who has the right to receive end of service benefit as per or calculated according to their basic wage. If we are during a specific situation that the employee accepts to reduce the salary during, imagine, 1 month or 2 months, after that period of time, the salary will be reinstated. The old salary will be reinstated. This measure, the reduction of wage, should be a temporary measure, not a permanent measure. Considering all this, my opinion is that the end of service benefit, if during the period of wage reduction, the employer decides to terminate the employee, I think that the end of service should be calculated as per the initial basic wage and not the reduced one. Because the reduced one is a temporary measure agreed between employer and employee to support the business of the employer, to allow the business of the employer to go on, to proceed during this pandemic. It should not be used as a way to try to reduce the wage and then pay a lower end of service benefit. And I don't think that if those questions arrive to the court in any time in the future, that the courts will accept such possibility. The reduction of wage or the agreement to reduce wage between employer and employee is limited to the wage, and in my opinion is not extensive to the calculation of end of service benefit. Vani, was it clear, or any other question?
No, thank you. I didn't know that the wage revision has to be temporary. The reduction is temporary. So yeah, thanks for the clarification.
It's at least it should be. It should. If you tell me a different thing, which is okay, I'm facing a situation that I need to reduce permanently my salary, the salaries of my employers. I think the situation here is a little bit more doubtful, because there are several opinions of here, even legal opinions, even court decisions. But normally, the law says that you can only reduce wage as implementing a court decision. So, in this situation that you are speaking, if you want to reduce permanently your salaries, what I would suggest is to terminate the current employment agreement, pay end of service, pay the benefits due to the employee, and then start new employment agreement with a different salary, with a different wage. Any other questions, Vani?
No, thank you so much, Ricardo. That was very useful. Thanks.
Ricardo, we have some more questions coming up.
One
Ronald?
question.
Yes, Tamer. Hi, Tamer. Please go ahead.
Hi, Tamer.
Yeah, Ricardo, I will give you a real example. We are working in a food and beverage company, restaurant business. And as you know that the restaurant business had been shut down in all the malls starting from mid of March. If I issue a termination letter for one of the employees, he passed already 1 year with 1 month notice. Shall I have to pay this 1 month notice even the facility had been shut down? Or
Yes,
if I have to pay full salary?
Yes, you have. The question is to be direct and simple without yes, you have to pay. Even if you look into the regulations or to the guidance notes issued by the Labor Ministry to employers and employees, they are very clear on that specific point. Employers may terminate contracts, however, they have to comply with notice and end of service and any other amounts due to the employees, that imagine overtime or something like that.
Okay. Thank you so much.
Right.
It's very clear to have to pay notice salary, even he stay in the accommodation.
Even if it says in the accommodation. In order to reduce wages or enter into an unpaid leave situation, you need to have an agreement between employer and employee. Otherwise, it's not valid.
Okay. Thank you so much for that.
You're
Ricardo,
welcome.
I have a question regarding employees that are outside the country. Article 85 says you cannot terminate employees that are on leave. Has there been any changes to this? Because I've got a lot of employees, I don't have work for them to bring them back.
Regarding this, I would like to refer you to the guidance note issued by the Labor Ministry to employers and employees. And they have a curious analysis on this situation. And they open the possibility to terminate contracts to employees that are outside the country. What they say is that this is an unprecedented situation. Employees that are not providing their work to the employer should enter into an agreement between employer and employee in order to sort this situation out. However, the employee retains its right to not accept any amendment to the employment contract, but the employer retains its right to terminate the employment contract. So, specifically replying to your question, there was no amendment to the labor law. However, in a situation that the employee has already used their annual leave, however, it cannot return to the country and resume its work, the employer is entitled to terminate the contract. Especially if it was suggested or offered to the employee to enter into a salary reduction or unpaid leave agreement, and the employee rejected.
Okay, well, like most of mine have been on unpaid leave since March.
Okay.
And, you know, we would pay their end of service. We would pay them probably lieu as opposed to them having to work it. So we would pay their end of service and pay them their notice period. But to bring them back, I have nothing for them. So, because our work is just falling off.
So considering this, I would say that you have to terminate. You have to inform them that you are going to terminate, and they have to provide you the appropriate bank account so you can proceed with the payment at end of service and any other amount due to the employee, and you still have to comply with notice period. So you still have to pay for that month or 2 months, depending on the how many years the employee are working for your company.
Okay.
Excuse me?
Good, thank you.
You're welcome. So let's, Mahmoud, give me just 1 second. We have 2 other participants that have raised their hand before. We will go and we will return back to you after. So, Ravi, can you proceed, Ravi, with your question? Ravi, are you there? So, Ravi is not there. Let's going to proceed. Maria, you have raised your hand. Do you have any question for us?
Hello. Yes, I do have a question. It's in regard of termination when the person is abroad. What we're gonna do with cancellation of their ID and the ticket, return ticket, for example, like if it's normal procedure, we have to give it to the employee or a transfer or ticket. What we do in this situation?
Okay,
because
Maria,
we cannot cancel them.
To the cancellation of the ID, of course, we don't have a solution because the employee is not here in Qatar to cancel the ID. So if we consider that if the employee stays more than 6 months outside of the state of Qatar, their ID will be automatically canceled. I think this will be what is going to happen. In relation to the payment of air tickets, you are completely right. If the employee is not here, you cannot provide him with a air ticket, with a flight ticket. However, you can pay him the amount or the cost of that flight ticket. And this would be what I would advise employers to do in relation to employees that are no longer in the country.
Thank you so much.
You're welcome.
Ricardo, I have a question from Ravi.
From Ravi, okay.
Yes, the question he had earlier asked was, how many months' salary are permitted during termination from the employer to the employee?
Sorry, could you repeat the question? I could not listen to you.
Sorry. How many months' salary are permitted during termination from the employer to the employee?
I'm not really understanding the question. Are permitted?
How many months? Yes, I will repeat slowly. How many months' salary are permitted during termination?
Is speaking the calculation about end of service benefits? Is that? I'm not.
It's to do with the
I'm not
termination.
calling Ravi.
Ravi, if you are able to hear us, can you speak up, please?
Ricardo, Ravi have written to the chat because he is unable to unmute. So he repeated the question.
Okay, sorry, I didn't notice that.
So let me go to the chat and try to understand better his question. How shall we consider compensation? Okay. So this is the calculation of end of service, Ravi. The calculation of end of service is, as per the law, 3 weeks per year of antiquity. So if you have an employer with 5 years, for instance, you have to multiply the basic salary of 3 weeks of 3 weeks of basic salary multiplied by the number of years that you have the employee working with you. Okay.
We have another question request from Mr. Rao.
The period that the employee was under unpaid leave should be considered also in the calculation. Okay. Even if you was, imagine, 3 months during unpaid leave, you have to consider that those 3 months in your calculation of the end of service.
Ricardo, am I audible to you?
Yes.
Okay, I have a question, please.
Rajendra, before going with you, Mahmoud was asking a question before, and I stopped him so he could reply to the person that have raised his hand. Let's go to Mahmoud, and then Rajendra will go back to you. Okay?
Hi.
Mahmoud.
To be honest, it's not a question. I just wanted to share an experience related to one of the attendees who asked about the people who went outside the country since March on unpaid leave, okay? Because I checked with the ministry itself regarding this. So we had the same scenario with a teacher who left in March on unpaid leave, and he couldn't come back after that. I contacted Dr. Abdul Rahman. He's a legal advisor in the Ministry of Labor, and he said the contract is becoming suspended due to the employee being unable to come back to Qatar. So we have the full right to terminate the contract, and considering the last day he left the country, to consider the day he left the country as his last working day and pay all of his end of service benefits and everything based on that date without any notice period or anything. I mean, this is the experience which we went through, and this is from the ministry, and I even can share Dr. Abdurrahman number for anybody, but because we faced the same scenario.
Perfect. Thank you for your information on this. It's very interesting, Mahmoud. For me, the problem is that the labor law does not speak about the suspension of contract. However, it's important to understand what is going to be the guidance that the Labor Department is going to receive, and the opinion of the legal advisor of the Ministry of Labor, of course, is very important. Sometimes we have to distinguish what is stated in the law and what is the practice. What is the practice that the court will adopt? What is the practice that ministries will follow? So these kind of practical insights are very useful. And if anyone has any practical insights, so please go ahead. We are here to discuss all these situations. In my opinion, I would say that due to the fact that there is no suspension of labor employment, this was not a solution at the first sight. But it's interesting to understand that the ministry is accepting this as a valid possibility.
Thank you.
Could the previous
Rajendra Rao.
First, Rajendra, exactly.
Yeah. Ricardo, I have some questions which are interlinked. Just bear with me, please. Now, let's take a scenario where an employee working in a government organization has been served a notice saying that his salary is reduced. Okay. Now, keeping the sentiments aside, now the notice does not say whether the salary reduction is permanent or temporary. So I understand based on our previous discussion, you said because of this COVID situation, it has to be treated this is temporary, right?
Right. Rajendra, first thing, notice is not an agreement. When I issue a notice to an employee, this is not an agreement that we are going to reduce the salary. So in my opinion, this is an unilateral decision from the employer and it is illegal.
Okay. Now, this brings to my next question. Like suppose, okay, for some reason, since it's a government organization and we have to abide by it, now suppose that we sign the agreement, the new agreement, which says our salary has been reduced, end of service benefits also reduced or whatnot, whatever it is. Now, this brings to my second question of yours, where you say any new agreement which has to be signed would supersede the previous agreements, right? Like the previous agreement would cancel out and the new agreement will come into picture.
What I said before is the employer has the right to terminate any employment agreement and he has also the right to enter into a new employment agreement.
Okay. Now, in this case, would this means that again, the employee's indefinite contract is going to start from that day? Because this is linked to the NOCs,
Okay, I'm going to give you the law says that if an employee is terminated and hired in the 2 months after its termination, the whole period will be considered in relation to his antiquity in the company. Of course, this is a new agreement, but also this can be considered the whole period. So you have to be very carefully in order to state that you have paid in relation to the first X years, 2 years, 3 years, whatever, that you have already paid for your end of service benefit.
No, let's just say that end of service benefit is not paid. We are continuing, the employment continues.
You're not going to pay.
Yeah, the employment continues, but effective of, let's say, 1st of August, the employee will get a reduced salary.
Yes.
Reduced salary from 1st of August, and let's just say hypothetically, from 1st of October, he'll get a new contract, backdating it to the 1st of August, saying that your salary has been reduced. Now, in this scenario, would the employee can the employee go to employer and say that, guys, my 5 years is over? Now,
Could you repeat your question?
Okay, in this scenario, can the employee goes to the employer and says that boss, the 5 years is over, irrespective of new or old contract because of this COVID. You are supposed to give me an NOC now.
Rajendra, your question is about NOCs more than about COVID-19 and all these situations.
Interlinked, Ricardo, actually. That's the reason, We are getting a new agreement. Let's just say we're getting a new agreement. Then what?
Okay, but still what we are discussing here is if your employee can go away and can terminate the relationship, the sponsorship relationship that he has with the employer after the 5 years. What I'm going to say to you, and very, very quickly, because this is not exactly the topic of our discussion here today, is, in my opinion, the 5 years that we have to consider the first contract also. It does not start a new time. The clock does not reset, okay?
Okay, Ricardo, thanks a lot. Thanks a lot.
Hello?
So let's try to proceed to other topic, and then we will get back to your questions. We were speaking before about wage reduction. As we have seen, the employer has not the right to do it unilaterally. So it has to be made through an agreement between employee and employee. Let's imposing annual leave. What about this possibility? We have created here a scenario, so we can discuss a little bit about this topic. You can read the scenario while I'm speaking. But bottom line, the management informed the employees that while the company is modernizing the assembly line, decision that which they decided to do because of the COVID-19 situation, the employees must take their annual leave. This unilateral decision is legal? From your point of view, what do you say? Mahmoud, go ahead.
What I think it's 100% legal.
Exactly. Exactly. To all of you, this is 100% legal. Why? Because Article 80 of the Labor Code states specifically that the employer shall specify the date of the worker's annual leave according to the work requirements. So it's legal for the employer to impose a certain time, a certain period for the annual leave of the employee. Any questions?
Ricardo, we have a question from Saeed Husseini, but before you take the question, I just would like to notify all the participants. See, we have a limited time, so when you're asking questions, please make sure that's within the topics that we have advertised. Otherwise, we would completely lose control and people are not going to get the benefit we intended to. Thank you. Saeed Husseini, please go ahead. Maria, would you like to ask a question?
Yes, thank you. I would like to ask a question. What about if employee rejects to go in the time aligned by the company to take their annual leave? They don't want to take. So we are asking them to apply for it and they are not applying. And as per our experience, we have said that there will be no carryover balance to the new fiscal year. So it will be all leaves which is not taken will be automatically vanished. So it will be not anymore in balance of the employee. Can we do that? Or how can we force the employee to take his leave if he is not applying for it?
In that specific scenario, what I would do, I would notify, as an employer, I would notify the employee that he must take his annual leave. And if he does not do so, those days are going to be considered as used, independently if he shows at work or not. Because the employer is entitled to decide the time and the period for the worker's annual leave. Is a right granted to the employer to decide the date. Normally, what employers do, they try to reach an agreement between employer and employee because it's better. We are not here to turn the life of anyone difficult or problematic. No, of course not. We try to support employees. However, if we reach to a point that there is a conflict, the right is the employer has the right to decide.
Thank you so much.
You're welcome.
Ricardo, Hoveda has a question. Hoveda, please go ahead.
Hi, Ricardo.
Hi.
Have questions related to the what you said that we can terminate the employment contract because the employee cannot return to.
I'm sorry, but could you? Sorry to interrupt you, but could you please speak a little bit louder because I'm having some difficulties to listen to you.
Okay. Okay. My question related to terminating the employment contract that you said that if the employee is outside the country, we have the right to terminate their contract, but we need to pay them the notice period. Did you get my question? Yeah. Now, I would like to ask about the limited contract. What if I have, let's say, because I'm working in a school?
Okay. Fixed term contract. You are speaking about fixed term contracts. What should you do in this situation? Correct?
Exactly. Yes, I have two types of employees. Some they travel and they will not maybe be able to come back before the school year, and the others, let's say that we may end up to a situation that the learning will continue online, and I have, let's say, a group of staff that we will not need during the year. So if, let's say, we have a fixed, say, term or duration contract, what we can do in such cases?
I'm not sure if I listened to all your points, but in most of the cases, when you have open term contracts, it's easy. The employer has only to provide the end of service, the notice to terminate the contract. However, the situation is different when we are speaking about fixed term contracts, because those contracts can only be terminated by an agreement between employer and employee. If any of them, employer or employee, terminates the contract unilaterally, he might be facing a problematic situation, unless the employer or the employee has a just cause to do so. Such requirements are stated in the law, and they do not include a pandemic situation. So, in these cases, what I would advise to employers is to try to reach an agreement with the employee to terminate the employment contract.
Yeah, but even if the employee outside the country and they cannot travel back to Doha?
Well, my opinion would be the same. Nevertheless, we have already listened from what Mahmoud told to us regarding what is being determined by the legal advisor of the Ministry of Labor, that in these situations they are considering that the contract is suspended and it can be terminated because the employee cannot provide his work to the employer.
Okay, thank you, Ricardo.
You're welcome.
Ricardo, we have a continuing question from Carla. Carla, would you like to go ahead?
Yes, I just wanted to ask, the company has the right to put the employees also on annual leave, but what if the employee doesn't have balance anymore? What if I already took my leave this year and my balance is zero, and then the company puts me on leave? Will this be unpaid leave, or how this will be considered?
In my opinion, could not be considered as unpaid leave. In that situation, we have to understand the following. If the company puts the employee on another leave and pays all the salary, all the basic wage plus the allowances, there is no illegality here. That situation is legal. However, there is also no benefit for the employer. So we have to understand also that if the employee has already used all its annual leave, and the employer requesting to not go to work during a certain period of time, as per the law, he must pay the salary, the basic wage, plus the allowances during that period. Okay. Thank you.
Ricardo, sorry to interrupt again. We've got another question from Janet. She's asking about the leave salary. whether it should be according to the temporary wage?
In my opinion, no. In my opinion, no. There is nothing in the law about this. Okay, you have to understand that the law speaks only that, and the law speaks only about the salary will be calculated as per the basic wage of the employee. However, if I agree with an employer to reduce the salary and then I use that to terminate the contract and pay a lower end of service benefit, I would say that the employee can claim bad faith from the employer side when he approaches him with such an agreement. Let's proceed with the topics here.
Ricardo, sorry, before you start, Mahmoud, could you share the name of the person at the Labor Department? Could you put it on the chat so you can share with everybody the name and the number, please? Thank you.
Sure.
There's a question here by someone which I feel needs to be answered in this at this point about unable to travel back home after termination. Who pays for the expense?
Sure. Ricardo, would you like me to read the question?
Yes, please, if you could.
Sure. If an employee is terminated and he or she is unable to travel back to home country, does the employer liable to pay him or her life expenses and accommodation until he is able to fly back when the airline resumes services?
This is a very, very good question. And I'm going to be totally straightforward with you all about this. Even here in my law firm, we had discussions between the lawyers about this topic. Why? Because in one side, the employer has the right to terminate the contract. But in the other side, he cannot return the employee to his home country, which is a duty. As per the law, the employer should return the employee to his home country when the employment contract is terminated. So there are two different positions in relation to this matter. There are the ones that say that the employer has only to pay until the termination moment. So after the termination date, he has nothing to pay to the employee in relation to accommodation or food or anything. There is a second opinion, which is mine. I consider that the employer must continue providing accommodation and food or money to buy that food to the employee until the moment the employee can return or can be returned to his home country. Okay? Clear to... So let's try to proceed a little bit in our questions, and then we'll return to your question.
Hello, hi Ricardo.
Hello, Said. Just let us proceed a little bit in our topics here, and then I will get back to your question.
Thanks.
Safety at work and COVID-19. When assigning employees to work locations that are a COVID-19 risk, can employees refuse to attend or work in such locations? Does anyone want to provide its opinion? Has anyone experienced this in your company during the pandemic?
I had a thing with not with my company, with 4 workers who didn't want to go because there were 20 cases. And we had raised it with the ministry. But the ministry said the company has taken all precautions, that the workers cannot indefinitely not go to work, that they have to turn up and see how it is if the company has taken all the precautions. But the workers prefer to quit and return.
Exactly, Vani. We have to understand that this is considering, by the answer to this question has to be considered in 2 different ways. In one side, it's the employer duty to take all the necessary precautions to protect workers during work or from any injury or disease that may result from the work. Okay? So, in this scenario, it's the duty of the employer to provide any protective equipment to the employees. If the employer provides such equipment to the employees do not have the right to say, I will not work in such location. I will not going to work to that place. Okay? Furthermore, the law also says that the protective equipment shall be paid by the employer, not from the employee, and shall not be deducted from the salary of the employee. Quarantine and sick leave. I think this was a hot topic also in some companies and in relation to some employers. Does the quarantine period shall be taken from the sick leave?
No.
Did anyone? Exactly. I'm not sure who spoke. I think it was Samar. Samar, yes. You are completely right. No. The quarantine, we have to understand, in order to explain this in a very simple way, the sick leave is something that is related with a specific person, while the quarantine period is something that is determined by public health reasons. Someone is in quarantine because of the danger of infecting other people. So this is a public health problem, and this is to prevent everyone to get an infection. The Labor Ministry specifically stated that the quarantine period will not be deducted from the sick leave. So this is something extra in relation to the sick leave. In relation to the second question, employees that were self-isolated but did not test positive. The answer is the same. In these cases, the employer shall not deduct any days from the sick leave. So let's listen to a few more questions. Saeed, you were asking?
Yes, yes, Mr. Ricardo. I have a question. My company has given few employees 3 months of unpaid leave. Point number 1. What are 3 months of unpaid leave?
Unpaid leave.
Yes. So point number 1, they have utilized some of their annual leave and rest of the days as unpaid. So in annual leave, what are the allowances have to be paid? And in unpaid leave, what are the allowances and how we can do the calculation? Point number 2, there are 3 days of Eid or 3 or 4 days of Eid holidays. Will it be paid in full because the employee is an active employee? He is not terminated yet. So will he get the full paid days for 3 to 4 days?
So I will try to follow your question.
Okay.
First, unpaid leave, it must be agreed between employer and employee. It cannot be imposed by the employer. Second, during the leave, as per the labor law, the payment will be calculated as per the basic wage, not with allowances. Okay?
Okay.
The third question, could you repeat, please?
My third question is, during this unpaid vacation, he will have 4 days of Eid holidays. Okay?
Eid holidays.
And yes, because he is an active employee, will these 4 days will be paid in full or only the allowances?
They should be paid in full.
Okay.
Because as per the law, these holidays should be paid in full.
And I have another question. In this 3 months of time, if the employee finds a job, okay, will he have to serve a notice period, or he can agree with the employer that this unpaid leave will be my notice?
Normally, they can agree.
Mm-hmm.
However, if the employer does not accept, then you need to see either if you can change your sponsor or not, or you need a knock letter, or if he's going to, and if you can, if you have to serve notice period, if he's asking so.
Okay.
The notice period is a right both of the employer and the employee. However, the parties may waive such a notice period by a simple agreement.
And for the unpaid leave, it will be housing allowance plus food allowance, right?
Sorry,
so,
could you repeat? For the unpaid leave?
For the unpaid leave, it will be housing allowance plus food allowance we need to pay. So how are we going to calculate the food allowance?
The law does not provide any criteria to calculate the food allowance. So it should be an appropriate amount to allow employees to have their normal necessities. But the law does not provide any way of calculation food allowance.
So
Thank you,
we
Saeed.
cannot. Thanks a lot. Thanks a lot.
I have to step to the other participant. Sorry.
It's okay.
Ricardo, we have a question from Janet. I hope I understand the question clearly. In case the employer considers to use the sick leave for the quarantine period and threatens the employee that if he does not accept, then can the employee file a claim at the time of resignation?
In my opinion, yes. The question is a question of evidence. Okay, the employee will have to prove that he was somehow forced by the employer to take those days as sick leave. And the evidence might not be very simple. So my only concern, or the concern that I would raise in this question, is the question of the evidence. But yes, the employee can raise that question at the termination, after the termination of the contract, of the employment contract.
Ricardo, I have two quick questions. There are cases of, already workers not being paid in full before COVID. And because of COVID, companies are making use of this to change the contract. But the problem has existed before. What is the redressal? Second, what about employees who have secured loans against their salaries? And now if they're going to be either terminated or if they are going to have their salary reduced, what happens to their liability? Because it's secured against their salary, right?
It's a question Very good. Both of them are very good questions. I'll start by the second one. There is not properly an answer from the law regarding those situations, because those loans are secured by the salary, and this is an agreement between the parties, between employer, employee, and the bank who accepted that way of securing a loan. If the salary is reduced, I would say that the parties should sit and renegotiate the conditions of such a loan. Because if an employee has to pay, let's say 100, and his salary is 110, of course he cannot pay such a loan, otherwise he will not leave. So, in my opinion, the best scenario for both parties, including the bank, would be renegotiate this situation, giving more time to the employee to pay and lower installments. Could you repeat Vani, your first question, please? I remember. Companies that before the COVID-19 were already in difficulties, not paying to their employees, and now they are using the COVID-19 situation to renegotiate the employment contract, correct?
Yes, that's correct. That's correct. Thank you.
Vani, you are totally right. This is something that is happening. Everyone knew about companies that were already struggling before the COVID-19 situation. And the COVID-19 situation only accelerated their financial problem. It's true. However, in this situation, we are thinking about an agreement. If the employer and the employee accept to terminate a certain contract and to enter into a new one, this is the freedom of contract. It doesn't matter properly if your problem started before the COVID-19 crisis, or if it was caused by the COVID-19 situation. If you, as employer and employee, accept to change a certain agreement, to amend a certain agreement, to terminate one employment agreement and start a new one, is your freedom of contract operating.
Sorry,
Vani,
can I have a question?
Vani, Vani, did you understand everything correct?
Yeah, I understood. But they can't be legally held responsible, the companies, for not paying the wages, because
no,
it's
for
not
paying the wages. No, for paying the wages, yes. And there can be legally sanctions even for not paying salaries. Yes. I did not understand that in your question. You are saying that they would agree that they would not pay the salary because they have to pay the salaries. They can agree, but they have to pay. They have to pay for the salaries, for the previous salaries, the ones that are in debt. Okay.
Okay. Yeah, got it. Thank you so much.
Because when you terminate the agreement and you start new one, such agreement does not erase the previous salaries that are due.
Okay. Thank you very much. This is really helpful.
So, Tamara?
Yes.
Hello.
Hi,
Hello?
Mr. Ricardo. How are you? Okay,
Hi.
I have a question. I work in a school and our summer vacation is during July and August as any other school. Some people are entitled for 40 days, some people leave, and some people are entitled for the full summer leave. In this case, if the people are, the situation now when you travel and you have to come back to Doha, you have to be quarantined 14 days. If the 14 days, including your annual leave, which is equal to 40 or whatever, or it should be including, the quarantine should be including your leave, or we have to add the 14 days on your leave. I don't know if you get my question.
I understand your question, and it's an excellent question. I think that people should be responsible for their decision. Meaning, if
they should
myself, yes, if myself as an employee, I'm in Qatar right now, okay, and I decide to go to my home country during the month of August. I know now, I know already that when I return to Qatar, I have to stay in a quarantine during 14 days. So I don't think it's fair to input such responsibility to the employer, meaning that the employer has to lose the employee during 14 days just because he decided to travel abroad. So in my opinion, and once again, this is not, we must understand, and sometimes I say in my opinion, most of these questions are completely new. The law does not say anything about it. So we have to construe what the law says in terms of the rights and obligations of the parties, of the employer and the employee. In this specific situation, the employee already had the knowledge that he had to stay 14 days in quarantine. So he should consider to return to Qatar with a sufficient advance to use those 14 days during the annual leave.
Okay, thank you.
You're welcome, Tamara. Let's proceed with our topics here. Stopping employees from traveling. We made also a small scenario here to our attendees to listen, to read, sorry. But the question is, the employer has the power to prevent employees from traveling to a certain country or to leave Qatar during the annual leave. This is connected with Tamara Sarkis' question. The answer is simple. The employer has not the power to prevent employees from traveling to a certain country or to leave Qatar during the annual leave. Okay? The employees have their freedom to go to their home country or to leave Qatar during the annual leave. However, and connecting this with the answer to Tamara, they have to consider that once they want to return to Qatar, they must comply with the 14 days of quarantine. And this is not, we have to distinguish two situations. One situation is in, imagine, March, April. Someone was working here in Qatar and the ministry decided that such person should be on quarantine. The reason doesn't matter, but it was a decision of the Ministry of Public Health. Such persons must go to quarantine. In these cases, this will not be deducted from sick leave because it's a right that is being granted by public health reasons. Differently, we have to understand the situation of an employee that is in Qatar, decides to live abroad, knowing already that he has to comply with the 14-day quarantine once he returns to Qatar. This should not be deducted from the employer's working day. This should be included in the annual leave, and the employee should make the proper arrangements in order to return to Qatar, already considering those 14 days that he's going to need to do the quarantine. Any questions in relation to this topic?
Hi,
Any other questions?
Anjali, would you like to explain your question? Was your question answered?
Yes, hi. The question was actually if a employee comes back from vacation and there is a mandatory quarantine period of 14 days. So the quarantine packages which government is going to announce, the cost of the package, is it from the employer or the employee has to bear the cost? This was the question.
the cost of the package, you are asking if the cost of the package is from the employee or the employer.
Correct.
In the way that this situation was announced, this is a cost of the employee, not of the employer.
Okay, thanks.
And I think in the situations that the employee is presently in Qatar, and he knows already when he's going to leave that he has to stay 14 days in quarantine, in those cases, I would say 100% sure that this is an employee duty to pay, because he decided to leave the country already knowing that he had to have a quarantine period once he returns to Qatar. So the cost of such package should be paid by him, not by the employer.
So those who are now in on annual vacation, once they're coming back, if the quarantine is mandatory, then is there the company has to take a call, or is there any law which labor law or ministry suggests on that?
There is nothing in the labor law, and there is nothing also in the rules and regulations of this mandatory quarantine package. So we have to consider this in a practical way. This is an obligation for someone to enter in the state of Qatar. That one has to comply with that obligation. In my point of view, this is not something that the employer has to comply with. Of course, you have to consider also that the employee tells you, okay, if you don't pay this, I'm not able to return to Qatar. And in that scenario, you will have to consider either to pay or not paying, but the employee will not return. Okay?
Okay, thanks.
You're welcome, Ashley.
Ricardo, Ravi has a question to do with the same point. He's asking whether the hotel booking, is that mandatory, or can the employee make use of the individual accommodation provided by the employer?
No. It's mandatory to stay in a hotel.
Okay, thank you.
Any other questions?
Ricardo, sorry, I wanted to ask, when we were talking about quarantine. So, for example, if person made a test but got negative, but still he needs to undergo the quarantine, can we as an employer deduct it from their annual leave?
No.
So this could be considered as a quarantine in any way, even positive or negative, right?
Even if it's negative, it's always considered as quarantine. It cannot be deducted from sick leave or annual leave. No.
Okay, and we faced that one employee already 3 times got quarantined. So that's why we were thinking to deduct it from his annual leave.
I understand. He got quarantined by decision of the Ministry of Public Health, correct?
Yeah.
So he has to do quarantine. He's obliged to. If he doesn't follow that mandatory determination, he will be committing a crime. So this cannot be deducted from sick leave or annual leave.
Thank you.
Ricardo, I have a question.
Yes, Said, go ahead.
Whatever number of days of unpaid leave, when the employer wants to terminate the contract, the end of service benefit will be included these unpaid days, or it is only for the paid days?
No. It will be including these unpaid days. The calculation of end of service will include the period of unpaid leave.
Thank you.
You're welcome. Finally, Yes, Maria?
Sorry, in the same question, which were asked just now, for the end of service calculation, for example, if in our company we have a reduction for 3 months and we have, let's say we have an agreement with the company and the employee after 1 month decided to resign, how in this situation we calculate the end of service clearance and end of service based on his basic salary or reduced basic salary?
In my opinion, in the basic salary, not the reduced basic salary. When the employer and the employee agree to reduce the salary during a certain amount of time, a period of time, they are not giving any agreement to calculate all the end of service or the future end of service based on that reduced salary. And I don't think also that this is also fair to the employee. And this could be also say that the employer acts in bad faith by making a reduced salary agreement and then terminating the employee, paying a reduced end of service benefit.
If I'm not mistaken, in the labor law it says that it will be paid as per the last received salary. So last received salary will be reduced.
Yes, but it's reduced as per an agreement made between the parties for a certain specific situation, not as a way of calculating the end of service. So in my opinion, if I understand your question and it's a valid point, but I don't think the courts will accept such interpretation.
If we, for example, divide it, we will calculate, it should be 21 days per year. If we divide it by 12 and multiply by 3 months, which is salary were reduced, and we will calculate for this 3 months on the base of the reduced basic salary, and the rest on the, will it be legal?
I don't think it will make a big difference for the employer in the end of the calculation. Only 3 months, if you calculate a reduced salary, I don't think it will make a difference, neither for the employer nor for the employee. So I admit that in those cases, neither one would complain about it.
Okay.
Because if you see the difference in the end, it's going to be very, very small.
Yeah, I'm talking as an example for 3 months, but what if the reduction was for 6 or 1 year? So in that case, it will still make some difference.
In that case, it may make a difference, but you have to understand this. It will depend on the activity of the employee. If you are speaking about, imagine an employee that has 1 year and a half, yes, it will make difference. But if you are speaking about an employee that has 5 or 6 years, this will be something almost irrelevant in the middle of it. And I don't think that any employee would bother to go to court to discuss about the difference of a few hundred reals.
Thank you so much.
So regarding the last topic, employers' closure of operations. As we have seen and discussed during this discussion, yes, the employer is entitled to terminate the employment contract. However, he has to comply with certain rules, which are the labor law rules. So the termination of the employment contract during the COVID-19 is exactly the same rules that he has to comply before the COVID-19 situation. There is no change. There was no amendment in relation to the obligations that the employer has to follow in order to terminate an employment contract. So we are speaking about payment of wages until the notice period and any other amounts due, like overtime, payment of end of service benefits, and providing return ticket to the home, to the country of origin. So this was our discussion about COVID-19 and labor law. I hope you all have enjoyed. I will take the last questions right now. If there is any question or any doubt about the topics that we have discussed, please let's speak only about COVID-19 topics. And
I have one last question, Ricardo.
Yes, let's go ahead.
To calculate the daily basic rate of an employee's final settlement, do you use 352 days since we don't, 52 days? How many days what do you use? Because employees don't work on Fridays. So do you discount those days?
This is not a COVID-19 related question, and this is a consultation to a lawyer. I will have to.
All right, I just may call you one day then. I'll call you. I'll give you a call.
So, COVID-19 related questions. You're welcome, Ronald.
Ricardo, we have one question from Janet. This is regarding the holidays which the government announces. Okay.
The 3-day holidays, the Eid holidays.
Yes. She has raised a question on that. If the employer is not practicing, that means these holidays, at the end of the employment, can this be considered as unpaid leave and included in the end of service benefits?
Included in the end of service benefits, no. What I can say to you is that as per the law, those 3 days should be fully paid. This is what the law says.
Okay.
Of course, if the employee agrees to an unpaid leave during that period, they have an agreement that such time will be unpaid leave. Okay, so it's unpaid for everything.
Okay. Thank you.
Okay.
We also have a poll to complete.
Okay, let's just finalize with the question of Maria. I think it's the last one.
Yes.
Yes, Ricardo, I just wanted to check with you for the not working Saturdays, since the government announced that Saturdays are considered not working, and we have one of the companies which is supposed to work in six working days. Is it legal for us to put them on the annual leave or unpaid leave if they are on the probation period?
Could you? I did not understand the last part of your question. So you were saying that you had a company, you had workers that were working had to work 6 days per week, but I did not understand the following part. Could you repeat, please?
Yes, they supposed to work 6 working days, but since the government said that on Saturdays companies should be closed, is it legal from our side to deduct these Saturdays as their annual leave or unpaid leave if they are not entitled yet?
I don't think both, neither one of them are legal. Okay. At least not as a unilateral decision from the employer. They cannot work to Saturdays, not because they don't want, but because this was something that was imposed by the government to the company. So this is, they are available to work. However, the employer cannot provide them work on Saturdays due to government regulation. So I don't think they are. You can deduct on them.
Thank you.
Okay.
And one more question on the Eid holidays. For those who stuck outside of the country, normally we pay this 3 days of Eid if person is on leave as additional days or reduce it from the annual leave balance which were taken. Shall we pay to those who is on unpaid leave stuck abroad, or we can skip it?
In my situation, if you have an unpaid leave agreement, it's an unpaid leave agreement. you will not pay anything during that period of time. Okay.
Okay. Thank you so much. That's the last.
So I think we don't have any more questions. Please correct me if I'm wrong. I would like to thank you all to attending this discussion. It was a pleasure. Malavan is pulling a questionnaire here for your answer. Please give us your answers. It's very helpful, so we can improve our discussion and our information in relation to this topic. Also, we'd like to announce that we are going to discuss these and many other labor law related questions in the upcoming live online training on Qatari labor law. It's going to be on the 17th, 18th, and 19th of August. It will be online, as I said before. And if you want to attend, please contact Serendib Training in order to enroll yourself. Thank you so much for being present. Thank you so much for your opinions, for your discussion, for your questions. It was a pleasure.
Thank you very much. If you don't mind, please complete the poll so that we can know how you feel about the program and how we can further improve the next time we deliver.
Thank you, Ricardo.
Thank you.
Okay, bye-bye.
Sure.
Thank you, Ricardo.
Is everyone able to see the poll?
Yes, I've seen and I completed already.
Oh, okay. If you could complete it for me, please, it'll be very helpful.